Welcome to Solving Citizen Legal Encounters. All right, today we're going to be at Judge McBurney's court where we have Max Pritchard, who showed back up on the surface. Max Pritchard filed a motion for a retrial on the case that I already covered. The link will be in the description below, but that was a long case and a lot of pieces to it. So you'll have the whole thing in here for you to look at. But now we're going to check out this hearing and see how everything plays out with his motion to start his new trial. And you'll hear some things going on. All right. Let's go.
All right. Good morning, Ms. Rivers. Are you able to hear us?
Yes, I am. Good morning.
Good morning. So let's first please have a quick conversation with Mr. Pritchett, and I'd like to have that on the record. So that's the case of 20 SC 176922. Mr. Pritchett went to trial a while ago, and there was a motion for new trial, timely filed. And Mr. Pritchett, good morning. Are you able to unmute there?
Yes.
Great. Good morning. I had you, and let me get you right there, added to this conversation this morning because we needed to confirm with you your plans for representation, whether for your motion for new trial, you were going to represent yourself, if you or your family would be hiring someone, or if Mr. Hewitt, who is on the call here, would need to be called upon to line up appointed appellate representation.
On my end, I am still currently confirming just private representation. Now, I did speak with the public defender office briefly a minute ago, as far as just letting them maybe at this point help with the process to the extent that is necessary and what is needed. But I know ultimately the ball is still really in as far as moving forward, it's still in the court's hand, because we at this point, I'm not aware of any transcript that has been produced regarding the trial, and I know that is needed to proceed forward with or without an attorney. Of course, for the new trial. Is that not correct?
So certainly a transcript is necessary, and you, if you're representing yourself, or your lawyer, is 100% entitled to it, and the ball doesn't really get rolling until there's a transcript. And so I guess in one respect, we can wait until the transcript's done and then reconnect with you and have you decide. It's just helpful for Mr. Hewitt's team if they know that they need to line someone up. There aren't a whole bunch of attorneys statewide who focus on appellate practice like this. So you don't need to commit right now. It sounds like maybe that's still a little bit in flux. I'm calling your case up right now just to make sure the transcript didn't sneak up on us.
It did not, Your Honor.
Okay. Mr. Armstrong's checked, and the last I've seen is there's an amended notice of appeal letter from you, Mr. Pritchett. There was one in April and another in May. So we are in this moment of pause. Ms. Rivers needs time to get the transcript done. But just typically what happens is we find out before then, all right, this is the lawyer for Mr. Pritchett. Here's who's representing the state. And we talk a little bit about scheduling. But that's more preparatory. You're right. Nothing can happen until that transcript's done, so that either you, if you're representing yourself, or a lawyer, can pour over it to say, hey, here's where the judge made a mistake. Here's where whatever happened. So why don't you tell me right now which way you're leaning, and then we'll find out from Ms. Rivers what she forecasts for completing the transcript. I don't know where this falls in her list of cases that she's working on.
I like I said, just me confirming just the private counsel that I have and my family has been in contact with. Of course, nobody has entered any appearance on the case as of yet. But again, that is still being confirmed. What I will do, I think at this point, just thinking about the conversation that I had with the public defender office, I will fill out the necessary forms. I think for their procedure as far as retaining counsel, there is some type of forms or questionnaire that they needed me to do. Just ultimately, if I was to lead in their direction, that needed to be complete to ultimately move forward. And I think that would have made their process easier if I was ultimately to end up in that route. So I know just I guess for them to be on proper standby and not just lingering, I guess I can fill those forms out for their offices. Ultimately, if that is the route I will take, it will be ready, at least to be taken. But at this point, nothing has been confirmed.
Okay, I think I follow all that.
Your Honor, may I mention something just because it's a possible snag and I want to make sure? I assume it's something that in this division of the court is not an issue. But because he represented himself at trial, I wanted to point out that applying for public defender assistance is good for establishing indigency, because that is what Georgia law has as the marker that establishes indigency is the public defender's office. And both the oral request for a transcript to the court reporter, but also how the transcript gets paid for is determined by indigency. And so if he files the indigency form and that goes into the record, that directs the court reporter to file it regardless of whether they're paid for it by other means.
Got it. Okay. That's a helpful piece of advice. So, Mr. Pritchett, that's yet another reason for you to fill out that paperwork that would document, assuming it's accurate, that you qualify for appointed representation. The transcript will be completed. That's not what Mr. Armstrong was saying, but the question of how it gets paid for, if it has to be paid for, is driven in part by your financial means. If it turns out that you've got $100,000 on your books at Wheeler, then you're either hiring a lawyer who would be paying for that transcript, or you're representing yourself and you're paying for the transcript. But we aren't in that situation right now. Let me ask Ms. Rivers, who I know is writing things down, if she could give us a rough forecast of when she thinks the transcript in this case will be done.
Mr. Pritchett's case is actually next up to transcription after this.
I'm sorry, I couldn't quite hear that.
Can you hear me?
Yes.
Yes, Mr. Pritchett's case is next up to be transcribed after Sanders and Pittman, and I forecast that to be around August to be complete with both cases.
Okay. Then why don't we do this? And then I want to hear from you, Mr. Hewitt, because we'll limit the number of times you need to plug in like this. It seems like if we got Mr. Pritchett and you, Mr. Hewitt, back on, and Mr. Armstrong or one of his colleagues in August, and Ms. Rivers and I work together, so I'll be checking in with her. But if it looks like that transcript is wrapping up, then we ought to get everyone together again, and that will truly be the crossroads for Mr. Pritchett, because he'll have more time to work through with his family whether they're retaining someone, or he will have completed the paperwork to get GPDC in the mix, and then he can let me know which of those three options, assuming he qualifies for GPDC representation, which of the routes he's going to pursue, and that will be an actionable clock will be ticking by then. There isn't anything we could do right now because there's no transcript, but by August there ought to be one. And so it'll be a little more pressing for Mr. Pritchett to say, hey, here's what I want to do. Mr. Hewitt, anything you want to add, or does that work for you?
That works for me. I just add just so Mr. Pritchett understands what I'm doing here. I'm not his lawyer. I'm the statewide supervisor of the appellate division. And so I'm just sort of hovering over this case. You know, if we do need to appoint somebody, then I'll get that. I'll make that happen. And but if he wants to go pro se, that's fine too. Or if he doesn't qualify, that's fine too. But
Right.
I'm just sort of here
try to facilitate things. And I sometimes when I do these, the defendant thinks I'm their lawyer, but I'm not. Okay.
He's putting that on record. I don't represent you.
Nope, I appreciate you flagging that. I think Mr. Pritchett understood that you're in that supervisory capacity, and I appreciate him pointing out, hey, without a transcript, it's sort of moot right now. So I think that's where we are. Mr. Pritchett, anything you want to add? I had muted you because there was some background noise. You got to unmute.
Okay, there is one concern I do want to address, and that is regarding your response to the motion and the rest of the judgment that I filed. And honestly, Mr. McBurney, it does seem odd because the response to it was just pointing out my untimeliness for the motion that was filed.
The arrest and judgment that he filed is the explanation here. So when a defendant has been convicted of a criminal offense, the defendant may seek relief from his or her conviction by filing a motion in arrest of judgment. A motion in arrest of judgment suggests that the judgment has not been legally rendered. The motion may be oral or it may be in writing. Although the defendant may have a statutory right in some states to file a motion, the motion is seldom used and is rarely granted by a trial court. Max Pritchett filed this motion because the indictment was not returned in open court and no minutes of the return of a true bill exists. The absence renders the indictment invalid and subject matter jurisdiction void. Subject matter jurisdiction cannot be presumed and must be proven once challenged. That's what he filed the motion for.
Rather than discussing the issue at hand, and honestly, the timeliness was impossible, and it don't seem how it was constitutional. It does seem like it violated multiple of my rights because the judgment was entered May 2nd. The last date that I had to file that motion was May 6th. That was 4 days after you attempted to sentence me to football numbers. So it just, I don't see how it was just constitutional as far as you ruling in the direction that you did on the motion, honestly, sir. And again, like I said, the main issue wasn't at hand. You're trying to hold me to a standard as far as the timeliness and filing that I don't believe that even the court are holding the district attorney to, because the main issue at hand was, okay, well, is there, a record reflecting the return of the indictment in court? Heil stood up in a hearing. There is a record of this. I have the exact timestamp on one of the videos that you have on your YouTube channel of Mr. Heil stating specifically that there is no minutes. Minutes do not exist of the return of the indictment being returned in open court. That's not even how the process worked. And it really was a clear statement that was against the laws and procedures regarding that process. And so again, the issue at hand wasn't addressed, and I feel like I was being held to a standard as far as filing that I was just I couldn't do it, honestly, sir. And,
Okay.
and so I can there be some type of needs to be some type of reconsideration that I'm just kind of asking for as far as that motion is concerning.
So two things. One, that may be something that you or your appellate lawyer chooses to bring up when when an amended motion for new trial is filed. But number two, I note in the record, you have already filed a notice of appeal of my order. So that's out of my hands. You have appealed it. You'll pursue that appeal, and we'll see where that goes. But I don't have jurisdiction over that order now because you have challenged it, and you will navigate the Court of Appeals channels consistent with that notice of appeal that you filed. So you, as I said, may end up weaving it into the amended motion for new trial. Can't do that till we get our transcript in August. But before then, you'll be able to continue to work on that appeal that you filed. Anything else, Mr. Pritchett, before we get Mr. Ponder into your seat?
Not at this point. Kind of caught me off guard there, but I think that's on my end. I think that is it.
Okay, well, we will get you back onto Zoom in August at some point to see how we're doing with the transcript and to get a more final answer from you about representation. Mr. Hewitt, appreciate you joining us. You're welcome to stay for the Ponder one, but he's got a lawyer. His lawyer's sitting here in court, and we're going to pivot to that now.
I think I have plenty to do today. I appreciate the invitation, and like I say, if y'all have any problems, you can have Miss Hansberry contact me on any of these appellate cases. I'm glad to straighten things out. That's what I do all day. Okay?
It is, and we appreciate your help. Thank you, sir.
Can I be excused, Your Honor?
Yes.
Okay, thank you. Mr. Pritchett, do you have something you want to say to me, or?
Mr. McBurney, can you just give me just a brief summary? Okay, after me filing the amendment to your motion, what could I expect next as far as that process?
So you have appealed the order that I entered that dismissed your motion in arrest of judgment. So you see what else is in the docket. You had your notice of appeal. The clerk's office has sent to you some information. It's a checklist that you're supposed to complete. They most recently sent a letter in May to you, and you'll work through that. That's what you need to do to ensure that the record that's relevant to the motion in arrest of judgment gets to the Court of Appeals.
And that's the problem. How do I get that how do I get the record? I mean, how do I get that record?
So the clerk's office transmits the record. You don't have to go around doing anything, but they sent you a checklist and they highlighted a couple things in that checklist that they're saying you did not include. And so you'll need to interact with them, not with me, about that. So you should be looking for that letter if you didn't receive it, although it was sent by certified mail and it looks like, so it should be there by now.
All right. Appreciate it.
You bet. All right. If you could get Mr. Ponder, please.
Thank you, Your Honor.
Thank you, Mr. Hewitt.
Okay, so we're done with this hearing and we will see what will happen in August. I am definitely going to keep up with this because I want to see how this progressed as the first time we went through this thing. So we'll see if he's going to get his brand new trial that he's looking for. But anyway, we'll be on it. All right, have a good day, evening, or night. See you around on the next one.